Prop 19. So we're really excited to have you. And then after Robert goes, we will have Matt Bunch, the CAR Government Affairs Field Representative, my former colleague, give us a legislative update on what's happening with Prop 19 in its implementation and what legislation is going through Sacramento in order to make some clarifications to the law and how that might change the proposition for you. So without further ado, I would love to have Robert begin. Thank you.
Okay, how's everyone doing? I'm Robert Bloom, so I'm going to share my screen now. Okay, and let me just do that. Okay. So you're seeing my PowerPoint? Okay, great. Okay, so my name is Robert Bloom. I'm a senior counsel. There's a lot of them with CAR, and I'm here to talk about Prop 19. So taxes, exciting stuff. But before I talk about taxes, I'm going to give this legal disclaimer. So that's basically what you see sort of all over this page. It's like plastered. Anyway, I'm not an estate planning attorney or tax expert, and a lot of the parent-child transfers especially are sort of estate planning questions, and they're really beyond the scope of this presentation. So this area is a highly specialized area. Anyone needs that kind of advice, they should speak with a tax or estate planning specialist. Okay, with that being said, we can move on. And we're looking at Prop 19. So what does Prop 19 do? What is it doing since it's in effect right now? Well, it's actually pretty straightforward. So it takes the existing system, which allows tax portability within all counties or even between certain counties. It takes this existing system and extends it. So under Prop 19, a homeowner who is 55 or over, a severely disabled person, or a person whose home was destroyed by fire, they can transfer the taxable value of their primary residence to a replacement primary residence anywhere in the state, regardless of the location, regardless of the value of the replacement primary residence, even if that replacement primary residence has a higher value, full cash value. And they can do this within 2 years of the sale of the original primary residence. That's 2 years before the sale or 2 years after the sale. And they can do this up to 3 times. Now, if the house was destroyed by fire, they can do it more. And this applies beginning April 1st, 2021. So it's in effect now, but we're going to discuss what that means a little bit more. I'm going to discuss what that means a little bit more in a couple slides later. So that's the black letter law. That's your basic law. And this is an improvement. This is an improvement over the previous system. So the previous system under Prop 60 and Prop 90, that allowed only a one-time transfer, and it could be done within any county. But if you're going to transfer your tax bases across counties, well, you are quite limited, and you could only do that within the 10 counties that I have here listed. Well, it happens that LA, Orange County, Riverside, San Bernardino, a lot of the counties that you do business in allow for that. But now the tax basis can be transferred across any county in the state. However, and this is a big positive for Prop 19. However, you could only do that if the value of the replacement property was equal to or less than the current one. So here I have a reference slide. People like to see this information in in a graph or a chart, and so that's what I have here. So here I'm you know what? I'm sorry, I skipped a slide. So here I'm laying out the big advantages that Prop 19 has over the existing rules. So first off, Prop 19 allows the property tax portability anywhere in the state. It's no longer limited to within the same county or between certain counties. And Prop 19 allows the transfer of the tax basis even if the property is of greater value. So it doesn't have to be of equal or lesser value, which can be a major point of frustration. And lastly, you can transfer the property up to 3 times. It's not just a one-time thing. So those are the big advantages that Prop 19 has. And sorry. So I said I was going to talk about this timing aspect. Well, since it's April 1st, and that's when Prop 19 was definitively going to take effect regardless of any other consideration, you can do the sales right now. So whether it's a purchase or whether it's a sale, if the closing takes place or took place on or after April 1st, you're within Prop 19. The client should be entitled to receive the Prop 19 savings benefits as long as they meet all the other criteria. Now, we're going to the second bullet point here. If you have a sale where one part of the sale, either the purchase or the sale, closed prior to April 1st, and the sale of the other property closed after, then you're kind of in an unclear territory. But the fact is, we're working on implementing legislation right now. So even those transactions where one half of the sale closed prior to April 1st and the other half closed afterwards, that will likely qualify, but it's going to have to wait for implementing legislation to clarify that exactly. So if any transaction that you worked on had that, then that will likely qualify, but it's not clear right now, not 100% clear. And the last circumstance is both the sale and the purchase of the property closed prior to April 1st. That's probably not going to qualify. There, you're going to be under the old system of rules, Prop 60, Prop 19, which I described before. Okay, so under the old system, Prop 60 and Prop 90, if the house was of equal or lesser value, then you could do it. If it wasn't, basically you're out of luck. But equal or lesser had a specific meaning under the old rules. Under Prop 60 and 90, when you purchased a property, you could purchase it at 105% if purchased within 1 year after sale of your original property. And you could purchase up to 110% if purchased within 2 years after sale of the original property. So when they said equal or lesser value, it did not mean exactly equal or lesser value. It meant more depending upon the timing of the purchase. And the main question then is, will this phrase equal or lesser value with this particular meaning, will this carry over under Prop 19? And right now, well, the answer is we don't know. When this law first came out, everybody assumed, well, I assumed, many people assumed that you would use the same definition, since that was the definition that was probably on the minds of the drafters of Prop 19. But right now, it's unclear, and there's a negotiation taking place between CAR basically and the Board of Equalization. The Board of Equalization, they don't really seem to want to, they don't want to go with this old meaning. They want equal or lesser to mean exactly equal or lesser, and that's that. Anyway, we'll see what happens. We'll see how that plays out. Okay, so if you have a transfer under Prop 19, then the question arises, well, what is the new tax basis of the property? And there's basically 2 rules. Okay, so the first rule is, if you're buying property, a replacement property, and that replacement property is of, quote, equal or lesser value to the original primary residence, then the taxable value just simply transfers to the replacement property. So you get to keep your current taxable value, no matter what it is, as long as the replacement property is of equal or lesser value. So that's the sort of first rule. And the second rule, which is really one of the big advantages of Prop 19, is that if the property transfers and the value of the replacement property is greater than the original, then you can still transfer your tax basis. However, you have to do so with an adjustment. And so the adjustment is this: you get to transfer your tax basis. However, you add to it the difference in sales price between the full cash value of the replacement property and the full cash value of the original primary residence. So I have an example of that. And the example is, it's right there. It's basically, so suppose you have a replacement property with a greater value than the original primary residence. So the original primary residence is 400,000. And the original primary residence taxable value is 400,000. And that original primary residence sold for 900,000. So the replacement property that you purchase is $1 million. So clearly $1 million is above 900,000. And what you're doing then is you're simply taking the difference between the replacement property and the original. That's 1 million versus 900,000. So it's 100,000, and you're adding that to the taxable value of the original property. So there's your new taxable value, 500,000. And that's basically how you calculate it. It's pretty straightforward, really. That gives you your new taxable value when the property that you're buying is of greater value. Now, in order to claim the tax savings, it's not exactly enough to just go through those steps. It's not enough to simply be 55 or over, use a property as an original primary residence, sell it, and move into a replacement primary residence. There's one more step, and that is the homeowner has to file with the county assessor to claim this tax savings. Now, the Board of Equalization just, what was it? Yes, on April 1st. On April 1st, these forms became available throughout all of California at every county assessor I checked. I looked at a couple of websites. And so now the Prop 19 forms, in fact, are available. If you have just recently purchased a replacement property, you should file them and claim these tax savings. If you don't do it immediately, you're okay. You have 3 years. I wouldn't wait for 3 years. I would do it like pretty soon. But if for some reason you waited 3 years, you'd have 3 years. And even actually, if you somehow missed the 3-year deadline, you could still go back and file the claim. It's just that you wouldn't get the full tax benefits. They would start you would basically miss out on 3 years of tax savings, and you wouldn't be able to recoup that. Whereas if you do it within the 3-year period, you're entitled to get all of the money back from the time of sale. Okay. Let's see. So I've had some common questions that come up, and I've put them up on this slide here. Things that sort of stumped me when I first got these questions, but I thought about them, and here they are. So the first one: if you purchase a property now and then move into it, okay, and you're using that property as your principal residence, does that somehow affect the fact that you're using your original property no longer as your personal residence? In other words, if you buy a replacement principal property and move into it, have you sort of lost the advantage of Prop 19? And the answer is no. That result is going to be very, very, very unlikely. So you have to use your principal residence within 2 years of the purchase of the new one, and you can purchase it 2 years before, 2 years after. Okay, and I have in there this phrase, subject to implementing legislation. So that phrase is going to appear everywhere, and I've already given you an idea of how ambiguous some of the answers are. But the fact is, the Board of Equalization, they want to, for the most part, what I'm gathering is they really want to keep most of the same rules that we're operating under with kind of minor tweaks. And this is a rule that we have now, or we had under Prop 60, and they're probably just going to keep it. And we have no argument with that. So there's no real debate. There's no dispute over that. So it's going to be the same. Okay. Second one, do I have to sell my original property? I've gotten this question a couple times. Like, can I just buy a new replacement principal property, move into it, and sort of keep my old one, or maybe even transfer it to my son, so I take advantage of an exemption there? And the answer is no. In order to get well, it's two no's, both the first question and the second question. So in order to get the advantage of Prop 19, the new property must undergo a change of ownership that subjects the property to reappraisal at full cash value. So if you're not selling your property, well, that's not going to work then. You have to sell the property, which is good for agents because you have to sell your property. So there's two sales rather than one. But anyway, that's how that works. So another question we've gotten is, it pertains to when you buy the property, what if another person comes onto title? So if I share title with another person on the replacement principal residence, can I still get the exemption? And the answer is yes. So what matters is if 100% of the replacement primary residence has changed ownership. And if that's the case, it doesn't really matter who else comes onto title. And finally, we got this question: what if I'm buying a replacement property that has a taxable basis less than the original? And so, like, I don't want to transfer my tax basis. It's not to my advantage. I'm not going to pay more. And the answer is, you never have to transfer your tax basis. Transferring the tax basis is something you elect to do. And if it's not to your financial advantage to do it, then you don't do it. Okay, so those are some basic issues with what we would call portability. And the next set of slides I'm going to talk about, they pertain to the intergenerational part of Prop 19. So Prop 19 has two parts. The first one has to do with portability, which is what I just talked about, transferring your tax basis when you buy a new original property. But the other part has to do with the intergenerational transfers, and that involves transferring a person's property to their children and grandchildren. Okay. So previously, all transfers of a principal residence to your children were exempt regardless of how the children used the property. They could rent it out, they could live in it. It didn't matter. And this principal residence exemption was unlimited. So 5 million, 10 million, it made no difference what the value of the original principal residence was. You simply got to transfer the tax basis. And in addition to this unlimited exemption for transferring your principal residence, the law allowed an exemption for all other real property up to $1 million. Okay. Now, that's the old law. So under Prop 19, it's changed. So under Prop 19, you only get the principal residence exemption if you continue to live in the property as your family home, right? Before, you could just rent it out. Now you have to live in it. There's another exemption for family farms. Okay. You also have to be the child or the grandchild of the person transferring the property. And in order to claim the exemption, you have to be eligible for what's called the homeowner's exemption or the disabled veterans exemption. That must be claimed within 1 year. Okay. Now, what about the $1 million for all other property? Okay, what about that? And the answer there is that's gone. So there no longer is that exemption. There used to be an exemption for all other real property up to $1 million. Now it's gone. So now the only exemption is transferring to a grandchild or child the principal residence, and the transferee must live in it. And by the way, this all went into effect on February 16th, 2021. So this is in effect now. And then the final question here is, if you do have this exemption for transfer to the child or grandchild, then the question is, well, how much will the new taxable value be? And I have I have a general rule, which is essentially you get to transfer the value straight up. So if a child or grandchild qualifies by continuing to use the home as the primary residence, then the property tax basis simply remains the same, and you get that. However, there is an exception. And the exception is, it depends upon if the value of the full cash value is much, much higher than the original tax basis. Okay, so if the value of the property is $1 million, the new value of, or it's called the assessed value of the property, is $1 million over the original taxable basis, then the new tax basis is going to increase. And the new taxable value will be the full cash value or assessed value of the property minus $1 million. So I know that's confusing. So that's why I have an example. And in the example, we assume that the family home is valued at $3 million. Let's assume that. But the original taxable value was only $500,000. Okay, well, that's quite a gap, $500,000 to $3 million. In fact, the assessed value is more than $1 million over the current taxable basis. So therefore, the taxable basis must increase. And the new taxable value is going to be basically the full assessed value minus $1 million. So that's going to be $2 million. Basically, you know, whatever if you have like a $10 million property with a taxable basis of say 3 million, then the new taxable basis is $9 million. You get $1 million off, and that's a way to think about it. It's probably an easier way to think about it. And instead of going through those calculations that I just went through, you can just say that you get $1 million off the current assessed value of the property. But of course, the tax basis will never be lower than the original tax basis. So that's the way to think about that. And I think we have, so here's a chart as well, which is a reference chart, just as a comparison between the old rules and the new rules. And then there's some other common questions that I've provided answers for. Well, actually, the Chief Counsel for the Board of Equalization has provided answers for. Before, I was just providing the answer, sort of speculating, but now the Chief Counsel for the Board of Equalization can provide his speculative answers. Do all children have to use the primary residence when they move into this property? So 4 children inherited, do all 4 have to move in? That would seem kind of uncomfortable, a big hassle. And the Chief Counsel says no, right? Why does he say no? Well, I don't think he gives a particularly good reason. I think he just thinks it's ridiculous to have all 4 children move into the property. So only one transferee is going to have to move into the property. And again, this is subject to implementing legislation. I don't think anybody's arguing for anything otherwise, so most likely that will be the result. And second question, does the property lose the favorable tax treatment if the child/grandchild stops using the property as a family home? And here the answer is yes. So, I mean, that's basically a big question that we've gotten constantly, which is how long do I have to live in this property before I can just move out and still get the benefit? And the answer is forever. There is no time period after which you can just move out and continue to get the benefit. You or some other family member needs to continue to use it as a principal residence in which you can claim the homeowner's exemption. So that's what the chief counsel is opining there. I think that's almost certainly going to be the case. That's where you get your use it or lose it there. Okay, so what else have I got here? Oh yeah, the family farm. Okay, so I said that the $1 million exemption, and we're still on intergenerational transfers here. So as far as intergenerational transfers go, I said that there was no longer the $1 million exemption for all other real property. However, you do have this new family farm exemption. That wasn't there before, it's there now. That was part of Prop 19 to help family farmers. And so the question is, sure, a family farm can transfer and get the tax savings under Prop 19. Does it have to be used as a residence? And the answer is no. There's nothing. We didn't really need a chief counsel letter to tell us this, but the chief counsel weighed in anyway. It's pretty straightforward from the law. There's just simply no requirement that the family farm be used as a principal residence. So right now, I mean, I don't think there's a lot of family farms in the South Bay or in Southern California. There used to be where I grew up. I grew up in Orange County, and there were actually like farms all over where I grew up. But now, not so much. So the big question with this family farm thing really is what constitutes a family farm? Like, let's say you have 3 parcels which are used all together. Are they combined into a single parcel, which would limit the exemption, or can you divide them? Anyway, it's a question that we don't know the answer to. It's going to be decided again through implementing legislation. Okay, and finally, the questions involving trust. This is also intergenerational. Can the transfer of a primary residence be the trustee of a trust? And using current law, the answer is yes, and most likely that will carry over. Now, it's really the same thing for the portability as well. So for portability, you can buy and sell your replacement property through a trust as well. And so again, subject to implementing legislation, this will very likely be the result. So I'm sorry about having to constantly tell you that these things are unsettled, that nothing's for sure. But I mean, I don't know, it's not my fault, don't kill the messenger, but the thing, if I had to explain it, I'd explain it this way. A proposition, the way it's written, is actually a very short document. But when you see the kinds of proposals that are put out as sort of tax legislation trying to combine all these things, it goes on for pages and pages and pages and pages. And I think it would have been impossible to have written that into a proposition. I mean, I don't think it can be done. So, and normally I believe in the past, there's always been a need for clarifying legislation whenever any of these propositions have passed. So what I'm trying to say is I think it's actually kind of normal and expected that there would be sort of a lot of ambiguity circling around these rules. Now, we have a lot of, so Prop 19 is this great thing for agents. Okay, I know some people don't like the sort of the tax consequences on the intergenerational portion, but in terms of promoting sales, creating efficiency in the marketplace, freeing up housing, allowing people to move where they want to move, not being restricted by the price, Prop 19 is great. And that's why I think CAR, when I say CAR, it's really the directors, big brokers across the state supported this. So it's not just a cabal of shady people working in CAR. It's like it's brokers across the state. They believe this was a good thing, and I have to think it is. So how do you get the word out? And there's always a fine line between, obviously, agents don't provide tax advice, but you can provide information. And we have information which is prepared for you to use, and it's on our website. Flyers. There's a PowerPoint which sort of can be used in-house. Social media marketing type things, Q&As. So you can, all of these things are available. All of these things are available on our website. And it's right here, basically, this special www.caprop19.org. Okay, so I think that's my presentation. So
Great. Thank you so much, Robert. If anyone has a question for Robert, we're going to address it at the end of the presentation. Just put it in the chat, or if you want to ask it yourself, you can raise your hand and we'll call on you and ask you to unmute. For now, we are going to move on to Matt Bunch, the CAR Government Affairs Field Representative for our association, for the South Bay Association of Realtors. I fought really hard to make sure that Matt, and only Matt, was our field rep, because he comes with all the information. He is our lifeline to CAR. So we're really happy to have him here. He's going to talk about the legislative updates and what's happening with Prop 19 and which legislation may move forward that will help clarify the law as it's implemented. So, Matt?
Hi, yes, and Julie, I continue to fight to keep South Bay as one of my associations. We're hiring a new field rep for Southern California, but I will be keeping South Bay in my portfolio. Again, my name is Matt Bunch, and I'm your Government Affairs Field Representative for CAR. And Robert has gone through and covered a lot of the information about how Prop 19 is going to be implemented. But as he said a couple of times, there is requirement for implementing legislation. And that's kind of what I'm going to talk a little bit about today. There's a couple of bills pending at the moment. The first one is one that we're supporting, that we're part of, and that is SB 539 by Senator Hertzberg. That bill is still in its introductory stages. We are working alongside the, although it's passed one committee already, we're working alongside the Firefighters Association, the Professional Firefighters Association, the Farm Bureau, and other groups who would stand to benefit from clarification in the law. There's still a lot of what ifs and things to be dealt with in there, so it has a slower road than we would have hoped. In particular, the Farm Bureau and the farm interests are concerned about how the implementation is going to go with the farm exemption. It doesn't bother us one way or the other in a serious way, but we're working alongside, and we have to wait for all the parts to align. We are pushing that. We do have great hope that it will be passed in the coming months and then signed into law. So that's the first bill, and that would give us a lot of clarification on some of those questions that Robert mentioned. The other bill I do want to mention is SB 668. This is by Senator Bates, and it would put a pause on the intergenerational transfer provisions of Prop 19. We're not supportive of this, in large part because although we're not a big fan of our own part of this legislation, and I'll get to why we did it in the first place, we did it in such a way that it would benefit our partners on Prop 19, as well as allow us to complete the exclusion that allows us to transfer properties between counties. We don't believe that SB 668 can viably pass and be enacted. And that's for a few reasons. One, it's unconstitutional. We don't believe that it can constitutionally be done without a vote of the people. We're changing state law that was passed by the vote of the people, and I'll make a simplification here and say it really needs a vote of the people to pass. The second reason is we don't think that it has the support of the legislature. There are labor groups and farm groups and us and many other groups that supported Prop 19 in its entirety. And that required the vote, wound up requiring the legislature to authorize Prop 19. We believe that it would be unlikely that SB 668 would even pass. And if it did pass, it's very unlikely to go into effect without a vote of the people. So that's kind of, we're keeping an eye on it, but we don't think that's going to happen. So why did we do all this? And before I do that, I'm going to share screen because I do want to point out that some of this information that I'm talking about is available on that same website Robert pointed out just a moment ago. And I'll share screen. So you'll see that this is our caprop19.org website. A lot of our information is on here. And if you click on Get the Facts, you'll have a lot of information about how it might benefit your clients. But we can talk a little bit about why, and of course, under CAR members, there are personalized flyers that you can use to send to your clients that might benefit from this. So if we look at intergenerational transfers, why did CAR sponsor this? Well, turns out that we believe that this was going to happen anyway. There was a lot of reason to believe that. The Legislative Analyst's Office had come up with a report not too long ago that explained the billions of dollars that could be generated in tax revenue if if the state eliminated the intergenerational transfer entirely. We didn't want to do that. But it became much more likely to pass as the LA Times did a series of articles that exposed some wealthy folks down in Malibu, the Bridges family, who inherited beachfront estates and rented them out, never living on the property, never getting a tax reassessment, and making money off that property. So there was a groundswell of support for changing that intergenerational transfer. It was low-hanging fruit. It was something that somebody was going to do, and they were going to fund their own pet project or just fund the general fund. We don't want that. We wanted it to fund something in real estate. And so we had our previous Prop 5, which is the inter-county transfers, buying up and buying down, and being able to transfer your tax base. And that was killed, if we, for those of you who remember Prop 5, it was killed because it cost too much. So we were able to pair this policy that was going to generate billions of dollars with this policy that we liked that was arguably going to cost money. And we were able to then fund Professional Firefighters Association, especially in fire-prone counties, and create a policy that was popular. And that's how we got it passed. So there's more information about this if you have questions about how it went into effect. The reality is our board of directors, which is made up of realtors just like all of you, including members from your association, thoughtfully considered this and all the alternatives. And then overwhelmingly, they supported going forward with what became Prop 19. And I see a question that, oh, I see. Yes, the website address, caprop19.org, is in the chat. And additionally, if you go to CAR members, you can log in using the same password and username you would use to log into the CAR website. And you can see our marketing materials, including a similar presentation to what Robert has just created. It's a little pared down, but similar presentation, so you can get an idea of this stuff after this meeting is over. Sample email letter you can share with your clients about the many benefits of Prop 19. And as I mentioned, customizable flyers that you can post online or send to your clients, whether customized or not, for specialized to victims of wildfire and natural disasters, for people with severe disabilities, and for all homeowners age 55 and over.
Where do you go for this on the MLS? Where exactly is this?
This is going to be if you go to CAR. So in this case,
yeah, on the
it'll
MLS. Yeah.
It'll be the caprop19.org. It's the same website that was just put into the chat.
No, I understand, but you said you can put this, you can get this on in your MLS.
I said if you
MLS, no?
No. So if you go to CAR
Oh,
members,
got it. Never mind.
Yeah, if you go to CAR
I see
members,
it.
yeah.
Mm-hmm. Never mind. Thank you.
But that concludes my my portion. But of course, we're always available. We'll be answering questions now, but we're always available for questions after the fact as well.
Appreciate that, Matt. Thank you so much. And for the audience, I think it would be good to mention too the projected market effects of Prop 19. How many additional sales was CAR predicting that this would create for our agents over the next year, the next several years?
Oh, I knew you'd be asking me that, and that information has long gone out of my head since the election has ended. But it was millions of new transactions in out years, statewide. I don't remember what that looked like by region. It's been a while since I've had to look at those numbers. I can get back to you on that.
That'd be great. Thank you.
And that was
I'm
largely,
sure those numbers.
a big portion of that came from the transactions generated by the inter-county transfers.
Yes.
But some of them also came from the presumed sales after intergenerational transfers.
Right. Perfect. This is probably a question for both of you. Actually, Robert, I got some questions on whether you would be sending out your slides.
Oh. Yeah, sure. I will send them to you and you can distribute them. Sure, no problem.
Okay, thank you. And before we go to the raised hands, I had a question from Tasha Hinchcliffe. Robert, regarding your first part, when you were speaking about portability and you had the question 1, question 2, yes and no. For question 2, you had whether the question I believe was, do I have to sell my property? ? And then the second question to that was, can I just transfer it to my child? And was that a no and no, like you don't have to sell your property if you want to transfer it to your child? Can you clarify what your answer was to that?
Yeah, sure. So let me pull up that slide really quick.
Yeah, it may help to have a visual aid.
We'll pull up this visual aid. And hopefully, I never know if I'm doing it right anyway. So yeah. So here it's the second question.
Yes.
So a client, let's say a homeowner, wants to sell their property, their original primary residence, and transfer their tax basis to their new primary residence, right? So that's and they can do that anywhere in the state. So the question is, what if they don't actually sell their original primary residence? So that's the first question. Do I have to sell my original primary residence? Can I just keep the property and transfer my principal residence to a new property? And the answer is no. You do not get the Prop 19 tax benefit when you do that, okay? And the reason is because in order to get that benefit, the original property has to undergo a change of ownership that subjects the property to reappraisal at full cash value. And so that's going to be true with the second question. Can I just transfer it to my son? So I'm not selling it to my son. Well, maybe I am selling it to my son, but the point is, because it's my son, assuming my son lives in it and it's my principal residence, that's an exemption, right? And so you wouldn't be able to get the benefit there either, because although it's a transfer, it has not subjected the property to reappraisal at full cash value. So in either of those circumstances, you're not going to get the portability benefit.
So you have to choose one or the other.
I would think so, yes.
That makes sense. Thank you. And there were, okay, let's go to the hands actually. Cecilia, you can unmute yourself.
My question is, thank you so much for this. My question is worse, and they both want to buy another property. How does that work for transferability with the property taxes?
Who wants to buy the property?
If they're getting a divorce, if a couple is getting a divorce and they live in the primary residence, but they both want to buy, who gets the transferability of the property taxes? They're both want to buy separately.
Right, yeah, I'm not 100% sure on that one, to tell you the truth, but I believe the answer is they have to basically choose between themselves as to which person would be entitled to that transfer of tax basis, but I'm not 100% sure on that one.
Yeah.
So it's like, for example, well, I mean, for example, you can have two people who, I mean, there's a lot of circumstances involving co-ownership, where essentially the Bureau of the Board of Equalization is saying you have to choose which person actually gets the portability. They have to decide amongst themselves. Now, it would be different if you have two people owning two separate a property with two separate dwelling units, like a duplex or triplex. In that case, they could each transfer their principal residence, based upon the value of their portion.
Okay.
Sounds good.
Thank
And
you.
to follow up on that, thank you, Cecilia, for the question. To follow up on that too, Robert, Tasha just asked, follow up on that. If you choose one of the spouses who split to get the transfer, would they also have 3 transfers with that person who?
I'm sorry, can I clarify my question, Julie?
Yeah.
No, actually what I'm asking is, because now you're allowed to have 3 transfers, there were a lot of questions going around of, in the past, that did have to be part of the divorce discussion, was, who got it. So now that you're allowed to have 3, couldn't both of the both spouses each take it, and then there's still a third that up for debate later, who gets the third one later?
Yeah,
Because
well,
now
that's okay, I see what you're saying. I mean, but we're assuming here that there's just one principal residence. That's really the issue. It's not that the limitation isn't they can only do it one time. The limitation is there's only one principal residence that they're transferring. So sure, each person can transfer up to 3 times now, but I'm not sure if that matters if there's still just the one principal residence.
Well, I know that the whole question of how it's handled with divorces has been a huge one amongst clients of how to deal with this, especially post-COVID, where it was either divorces or babies that resulted. So there were a lot of questions on the housing side. Is CR going to be able to follow up and try and get some clarity on that?
I mean, we have a Q&A which discusses current rules under Prop 60 and Prop 90. And I don't know if it's fairly detailed actually.
Okay.
And I don't know if it addresses this specific issue, but we'll definitely be updating the Q&A. The thing is, we won't be updating it until Prop 19 implementing legislation is passed, because it's almost kind of pointless to do that. So there's going to be a limbo period where we're going to have some idea of what the answers are. Like I gave you like a lot of tentative answers, with the constantly throwing this caveat, depending on implementing legislation, right? I mean, we're going to be in that boat for a number of months, I would think, and at that point, the Q&A will definitely be updated. So, I mean,
Sounds good.
this is a kind of a question that has basically been around forever. It's not a new question. It's just has more applicability now, since the property transfer tax, the transfer of the property tax basis can now go everywhere in the state. But I don't think the answer is actually going to be any different than the current answer. So like I said, as far as I've looked at, I don't know what you've looked at, Sean, but I mean Matt, but I've looked at a number of proposed regs and proposals put out by the Board of Equalization. They're not in any huge hurry to completely change all the rules. They feel quite comfortable basically implementing legislation and regulations which essentially replicate most of the current rules. So I mean, the current rule allows for X, that's almost very likely to be the current rule going forward. I mean, there's a couple circumstances which are different, like for example, the definition of severely disabled is being loosened up a bit. It was previously severely and permanently disabled. Now it's severely disabled. That looks like it's going to be the answer. This whole thing with equal and lesser value, it's driving us crazy. That's a point of contention. We honestly don't know how that will ultimately play out. We don't know various definitions of family farm, but everything else practically you read on the Board of Equalization website, their Q&As pertaining to 69, it's almost certainly going to play out in the same way as the current rules.
And that's our intent. I mean, with a lot of the legislation, implementing legislation that we are promoting, and of course, there's regulations as well, we're not looking for big changes as to all the definitions and the way we work things through.
Okay, thank you both. We had a question hand raised from Danielle. You may unmute, Danielle.
Hi, yes. So I have a client that was left at home from their parents, and it was left to them and 4 other children, so 5 children total. And they're all over the age of 60. 3 of them wanted to sell and 2 didn't. So what they ended up doing was buying out the 3 other children. So now there's 2 owners on it. So they rented it out for a few years, but now one of them wants to reside in the property and buy out the other owner. So once they end up doing that, would the new owner now eventually be eligible for Prop 19, or is there too many transactions within that time period?
So one of the children, I'm not sure if I'm gonna be able to answer this. It sounds
It's
kind
very
of complicated. This is where the disclaimer that I gave at the start comes into play. So one of the children is in fact living in the property as a principal residence now.
Correct.
Okay. I mean, they got originally, I mean, I suppose they were eligible for some portion. I'm not sure I'm not even sure if they were eligible for the original portion of the intergenerational exception. But I mean, to the extent that they're living in the property now and using it as a principal residence, that person should be eligible for the portability exemption. So I don't think there's anything precluding you from taking even a very low property tax basis and transferring it to the new property. So I think they can do that.
Great, thank you. Benjamin, you had your hand up. Go ahead and unmute.
Hello, can you hear me?
Yeah.
Okay. A quick question. I apologize if you may have already answered this. I've been in and out working and trying to pay attention to the webinar at the same time. But with the transfer from a son to, or from a parent to a child, you said that does not qualify due to the house not being reappraised. Is that correct?
I mean, in general, you have the exemption for intergenerational transfer. It applies when the property's first being used as a principal residence.
Uh-huh.
And then the basic rule is if the child or grandchild uses that property as a principal residence, you transfer the tax basis. That's the basic rule.
Okay.
However, there's an exception. And the exception has to do with if the assessed value of the property is beyond $1 million over the current tax basis, then you're going to raise, that tax basis is going to go up. And so it goes up, essentially you get $1 million of tax basis free.
Okay.
If you have let's say you have a property has a tax basis of $1 million, but the value of it now is $3 million. Okay, well, that tax basis is going to go up. You don't get to keep your $500,000 tax basis. The new tax basis will be $1 million minus the current assessed value of the property, $2 million. So you subtract $1 million from whatever the assessed value of the property is, but you're never going to go less than what the original taxable value was.
Right, correct. But they don't have to actually purchase the property. It could be a transfer to also qualify.
Oh, okay. No, they don't. They don't have to purchase. They can just receive it. Yeah, it can be. That does not require a sale.
Oh, okay. Okay.
And I mean, boy, I hope it doesn't.
Right. Yeah. Okay.
All right.
So,
Thank you for your question, Benjamin. We had another question just regarding the definition of a primary residence and whether that's been clarified at all. There were concerns that if a homeowner goes into, a long-term living situation or a long-term care home, that the primary residence wouldn't be considered their primary residence anymore. So therefore they wouldn't be able to pass it down to their child. Is that the case? Have you heard anything different?
well,
Or is that
to tell
something
you
that
the
we're
truth,
clarifying?
I mean, to tell you the truth, I haven't really thought about that question. At what point does moving into a long care facility, does that somehow negate the primary residence? I mean, if I look at the sort of the definition of primary residence, let me see if I think I had it here. Well, I'm not finding it, but basically you have all these sort of indices of whether something is a primary residence. I intend to live there. I use it as the place I normally reside, and then where's your driver's license? Where do you go to church? Where do you work? All these various tests. I mean, I just haven't looked at that question to see at what point moving into a long care facility would somehow create a new primary residence. So I couldn't really answer that question. I'd have to think about it.
Gotcha. Perfect. Thank you. I'm glad we could stump you a little.
Okay. Yeah, it's not that difficult to stump me, to tell you the truth, though, honestly.
Wait, Benjamin, did you have another question?
Yeah, sorry, I had one additional question. Does it make sense, let's say a grandparent, they're older before passing and they plan on transferring a property to their child. Is it a good idea to file the claim now before they even, while they're still here? Or how would that work? How would that work?
Right. So the person who files the claim is the person who is the transferee, the child or the grandchild.
Oh, okay, got it. Oh, okay. Oh, not the, okay, perfect.
They'd be jumping the gun, I think.
Oh, okay. Okay, got it. Got it. Okay, thank you.
That's a great clarification. I think we all needed to know that too. All right. I don't see any more questions in the chat. I think we're going a little bit over our time, but this webinar, this meeting is recorded. So if anyone needs the link to the recording, you can email me. I'll put my email in the chat as well. And thank you, Matt Bunch and Robert Bloom. Do you have any closing words for everyone before you leave us?
Feel free to reach out to us with additional questions. Julie will have our contact information, and if you have further questions, we can't answer really specific individual questions, as Robert said, but we're always happy to help where we can.
Yeah, I agree. I mean, you can always call the legal hotline if you have this kind of detailed question. I think we can figure out a lot of the answers to these questions. It's just it's kind of a little tricky to do it on the fly. So I'm sure I could answer like all of these questions given like 15 or 20 minutes to figure it out. So just call into the legal hotline if you have a question of this kind.
Great. And I'm putting the number for the legal hotline in the chat as well, so that everyone has access to that. With that, thank you so much, both of you. We really appreciate all your time today, really parsing this out for us in this very changing environment. I don't know, people are coming into the waiting room still. See, that's how excited we are to have you. People are coming in after the event has closed. So thank you again. And I will put more information out there, and please let me know if you have any other questions, and we'll get it over. And please use the CAR legal hotline. I think it's a great resource for all our members. Take care, everyone. Have a great rest of your day.
Thank you.
Bye.